On 11 November 2023, the Supreme Court gave its verdict on the Union government's 2019 move to amend Article 370 of the Constitution. The abrogation ended the special status conferred to the erstwhile state of Jammu and Kashmir. The court held the constitutional order that abrogated Article 370 as valid. Several petitions was filed challenging the presidential orders of August 5 and 6, 2019, as well as the Jammu and Kashmir Reorganization Act, on the ground that they are unconstitutional. The key questions of law raised in the proceedings are whether the status of J&K had not become permanent after the Constituent Assembly refrained from taking any decision on Article 370 before its dissolution in 1957, whether the latter effectively prevents the Union government from unilaterally altering the state's relationship with India, and whether the initially temporary provision has now attained a permanent character. On August 5, 2019, the President issued the Constitution application to Jammu and Kashmir order, which inserted a new provision, Article 367(4), in the Indian Constitution. This replaced the expression Constituent Assembly of the State in the proviso to Article 370(3) with Legislative Assembly of the State. The same day had seen the Rajya Sabha abrogate Article 370 and pass the bill to reorganize the state of Jammu and Kashmir. The next day had seen the Lok Sabha pass the bill and the President declare that Article 370 had ceased to apply. Issues with the abrogation of Article 370. About Article 370. Article 370 of the Indian Constitution is a temporary provision which grants special autonomous status to Jammu and Kashmir. All the provisions of the Constitution which are applicable to other states are not applicable to J&K. For example, till 1965, J&K had a Sadr-e-Riyasat for Governor and Prime Minister in place of Chief Minister. In a nutshell, according to Article 373, the President would require the recommendation of the Constituent Assembly of Jammu and Kashmir to make such a change. However, the 2019 presidential order adds a subclause to Article 367, replacing it, about Article 367(4). Article 367.4 replaced the terms Constituent Assembly of Jammu and Kashmir to mean Legislative Assembly of Jammu and Kashmir. Conversion of Jammu and Kashmir into a union territory is in violation of Article 3, as the bill was not referred to the President by the State Assembly. Article 35A, which originates from the provisions of Article 370, stands null and void. Article 35A empowers the Jammu and Kashmir legislature to define the permanent residents of the state and their special rights and privileges. In SBI Jawaharlal Nehru 2016, the SC held that Article 370 cannot be repealed without the concurrence of the Constituent Assembly of Jammu and Kashmir. Verdict of Supreme Court J&K did not retain internal sovereignty or element of sovereignty after the proclamation of November 1949. President and Parliament are not impeded to take over as governor, state legislature, after proclamation under Article 356. Article 370 is only a temporary provision. The bench rejects petitioners' arguments that Article 370 was of a permanent character and beyond the amending powers of the Parliament. The President had the power to issue a notification declaring that Article 370 ceases to operate without a recommendation of the J&K Constituent Assembly. It is a culmination of the integration process. The CJI notes that Article 370 was only a provision to take care of the transition from a princely state to the Union. It was an interim arrangement to tide over the war at the time. Even the textual reading of Article 370 shows it as a temporary provision. Concurrence of the state legislature not required to apply all the provisions of the Indian Constitution to Jammu and Kashmir. The President sent a not wrong in not taking concurrence of the state legislature. The Constitution of J&K is now inoperative. It was only made to fill gaps in the Indian Constitution concerning the state after abrogation of A 370 and application of the entire Indian Constitution to the state. the J&K Constitution implicitly serves no purpose. No need to examine whether J&K Reorganization Act, after Solicitor General appearing for centre, said the Union Territory of J&K would be returned to statehood. Elections to Jammu and Kashmir Assembly should be held before September 30, 2024. Justice Kaul recommends the constitution of a Truth and Reconciliation Commission, the setting up of an impartial Truth and Reconciliation Committee to investigate and report on the violations of human rights, both by the state and non-state actors at least since the 1980s, and recommend measures for reconciliation. The commission must be set up before memory escapes. The exercise must be time-bound. There is an entire generation of youth that has grown up with a feeling of distrust, and it is to them that we owe the greatest day of liberation. In his verdict stated that the purpose of Article 370 was to slowly bring Jammu and Kashmir on par with the other states of India. The requirement of recommendation of J&K Constituent Assembly cannot be read in a manner that makes the larger intention redundant. But there are certain impacts of abrogation of Article 370 on Jammu and Kashmir, which should not be ignored, as geographically and metaphorically, Jammu and Kashmir is the crown of secular India. Its people and leaders had chosen secular India over Pakistan. The government of India has to convince the majority of the people of Jammu and Kashmir that greater integration with India will provide them with more opportunities, provide more freedom and space, and strengthen their rights much more than the alternatives proposed by other mainstream parties or separatists. Further, India should take the people of J&K into confidence, bring development, which includes all sections of society, and restore statehood as per its initial promise.